can you please be seated so we can begin the program? Welcome to the third annual Conference on Media and Democratic Governance. I'm Michael Gershowitz, a member of the faculty here at the School of Public Affairs and Administration. And I'd like to start by introducing our dean. To my far right, Dr. Mark Holzer, and the co-chair of the conference, Dr. Uchenna Ekwo of the Center for Media and Peace Initiatives. We've just concluded a memorandum of understanding between our two organizations, and Dr. Holzer and Dr. Ekwo are going to sign that agreement at this time. Mark, would you like to say a few words?
Yes. I think that this is a significant partnership that we're entering into because the very foundation of our government has to do with a free press. And if you go back to the founders of our country, such as Thomas Jefferson, Jefferson repeatedly said that a free press is the foundation of our democracy. Free press is the foundation of our democratic process. Without that sunshine, so to speak, that the press shines on what government is doing, but also what business is doing, what people are doing in terms of all kinds of relationships, we wouldn't really have a thriving democracy. And I think that's in some ways become the model for the world. But yet there's not enough support for the media that way. And I think what we've seen, let's say the Rupert Murdoch model in a sense, is the corruption of the press in a way. So what we're really doing by signing this MOU is empowering the press in terms of our cooperative efforts to help support public policy, to help support the discourse, the debate on public policy, which ultimately preserves our freedom, ultimately helps us maintain a peaceful world. So I'm very enthusiastic about this, and we look forward to all the support we can give to this.
Dr. Ekwo?
Yes, thank you so much, Dean and Dr. Gershowitz. As a matter of fact, Center for Media and Peace Initiatives is an organization based in New York, and we are so interested in how the media can really promote governance and good governance, and indeed, help in building peace, across the different cultures. We are made up of different journalists from different countries around the world, and at the conception of this program or this partnership, we thought about how we can help, especially diaspora journalists, to empower them to learn certain rubrics about reporting and covering governance, so to speak. And because of the reputation of Rutgers in issues of performance measurement and all that, and also public administration issues, we thought that would be a very good school to reach out to and see how they can also help to provide some professional development to some journalists who happen to come from different parts of the world who are in New York. And as you know, New York is more like the headquarters of the world, so to speak, when it comes to media, and in fact the media capital of the world. So everyone is there. So, and we've been going on with this annual series for the past 3 years right now, and it comes to a point when we want to really formalize our relationship, and hoping that the partnership will continue to grow, and they will learn from the school, and to also should be able to impart certain basic knowledge to some of our members. And thank you so much for this opportunity, and I also thank Michael for making it possible. Thank you very much.
And now for the signing.
So we're going to sign multiple copies of make sure nothing is forgotten. Yeah, we should have a box of pens there. Distributed. So we use the same date format.
Yes.
So we want to shake hands.
Hold on.
We'll open this up. Okay. So, okay. 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 So,
The deed is done.
Yeah, thank you.
so we have launched this
Yeah,
check.
yes.
Right? And we'll proceed to the work of the conference. So,
We'll proceed to the work of the conference, but before we begin the first panel, I'd like to introduce our third conference partner, the New Jersey chapter of the Society for Professional Journalists. Bob, would you like to say a few words as the...
I think Miriam would be the more appropriate.
Miriam, you're on.
Well, thank you. It's been a pleasure working on this conference committee. Just a few words about our mission as an organization. We want to do. We realize that the media environment has just been upended, and for the last 10 years, it's sort of been in this mode of trying to figure out, how do we adjust to the internet? People are losing their jobs. People are working in a new environment where sometimes, reporters and editors and publishers all rolled into one. The newsroom with that, backup of experienced reporters, there to sort of, help the newbies. It's a thing of the past. But I think we're committed to being part of the conversation about where journalism is going and how to keep journalists well-tooled in order to adjust to the realities of the 21st century. So that's why we're part of this, and thank you very much for bringing us in.
Thank you.
I want to thank Michael Gershowitz for really fostering this effort. I think that he's really put in efforts above and beyond what anyone expected. And also, Michael is a journalist of long standing. Probably, you might have more experience going back further as a journalist than anybody else in the room. Back to the 1950s, right?
Same one.
Right? So I think that we have a lot of experience here, many other ways. I started a student newspaper when I was in college to compete with the limited point of view of the official newspaper on campus. I called it Contrast. So I have a feeling for this sense. But I think we have a wealth of experience to draw on, but I particularly wanted to thank Michael.
Thank you very much. And now I'm going to ask the members of the morning panel to please step forward and take their places. Thank you, Mark. You can sit in any order. I'll introduce you in the correct order. For those of you who came in early, We have a registration form and a lunch order form available. We need to call in the lunch orders by 11 o'clock at the latest, so if you haven't signed up for lunch and you'd like to have lunch, at some point, please step down to the lobby and complete a form, and we'll make sure that your lunch order is provided. And now it's time to begin the work of our panel. The first panel deals with the Bridgegate scandal and investigation. I'll introduce the speakers one at a time as they speak. Our first speaker, three to my right, is Tom Mcleod. Tom was open governance attorney at the American Civil Liberties Union of New Jersey from 2012 until last month. He graduated from the Rutgers School of Law in Newark in 2010 and was licensed to practice law in both New Jersey and New York in 2011. He also holds a master's degree in sociology from the University of Wisconsin and a bachelor's degree in criminal justice from Northeastern University. Prior to becoming an attorney, Tom worked as a job coach and case manager for individuals with disabilities in Wisconsin, and at one point early in his career, he investigated attorney misconduct on behalf of the Massachusetts Board of Bar Overseers. Tom was also a foster parent in Wisconsin and is currently licensed in New York City, where he resides in Staten Island with his wife, 2 foster children, and his dog. Thank you, Tom.
Thank you. This morning I'd just like to give a little idea about what the American Civil Liberties Union's interest in the Bridgegate controversy is, and kind of from an open public records perspective. Over the past few years, the ACLU of New Jersey has become increasingly interested and concerned about the government's handling of electronic records and email in particular, and especially about the use of personal email accounts by government officials. For example, in 2012, the ACLU of New Jersey asked Christopher Cerf, who was then the acting commissioner of the State Department of Education, to preclude DOE employees from using their personal email accounts to conduct public business. Commissioner Cerf soon took steps that seemed to comply with the ACLU's request, although the organization later discovered that the commissioner's apparent compliance did not include, for example, temporary consultants, some of whom were never issued governmental email accounts by the DOE. Also in 2012, the ACLU filed a lawsuit against then Mayor Cory Booker, who sought to prevent the Secondary Parents Council, a voluntary organization of parents and grandparents of Newark public school students, from accessing, among other things, emails sent to and from Mayor Booker's non-governmental email account regarding a $100 million donation that Facebook founder Mark Zuckerberg pledged to the Newark Public Schools. The lawsuit successfully provided the Secondary Parents Council with access to these emails from Mayor Booker's non-governmental email account, largely because the emails related to the official business of operating Newark's public schools. Indeed, the public's ability to access emails sent to and from non-governmental email accounts generally depends on the fact that the emails were used for the purpose of conducting official public business. For those of you who may not know, many of you probably do, New Jersey's Open Public Records Act, or OPRA, even incorporates this idea directly into its definition of a government record, which includes, among other things, any data processed or image processed document or information stored or maintained electronically that has been made, maintained, or kept on file in the course of his or its official business by any officer, commission, agency, or authority of the state or of any political subdivision thereof, including subordinate boards thereof. That includes counties, municipalities, school boards. Since at least 2005, the Government Records Council, the agency that Oprah created to help adjudicate denials of access to government records whenever the complaining requester chooses not to file a lawsuit in Superior Court, has recognized that emails are government records even if they are sent to and from non-governmental emails accounts. OPRA was passed or became effective in 2002, so that was shortly after the law became effective that this was recognized by the Government Records Council. In 2009, the Appellate Division of the New Jersey Superior Court reached a similar conclusion when it determined that emails regarding public business, including those sent to and from then-Governor John Corzine's private email address, met OPRA's definition of government record. Governor Corzine's emails may well have been made publicly accessible too, had the court not further determined that the executive communications privilege rendered them exempt from disclosure. With respect to the current political controversies that the news media has dubbed Bridgegate, the government agency at issue is the Port Authority of New York and New Jersey. Created by an interstate compact between the governments of New Jersey and New York, which was then approved by the government of the United States, the Port Authority is not currently recognized by New Jersey courts as being subject to OPRA or to New Jersey's Open Public Meetings Act, or to New York's Freedom of Information Law or Open Meetings Law, for that matter. According to a 2011 federal court decision of the Southern District of New York, the Port Authority is not subject to the Federal Freedom of Information Act either. Thus, the Port Authority is only subject to its own Freedom of Information Code, and it can decrease at will the public's access to information regarding its actions. Needless to say, this situation is far from ideal. Probably due to the comparatively greater obscurity enjoyed by the records of the Port Authority, it was the personal emails of Bridget Kelly, a governor's office employee, that the news media apparently used to shed light on the circumstances surrounding the Port Authority's controversial closure of several lanes of the George Washington Bridge late last year. The resulting uproar prompted the ACLU of New Jersey's initial response to Bridgegate earlier this year, at which time the organization wrote a letter to Governor Chris Christie, Acting Attorney General John Hoffman, and several leaders in both chambers of the New Jersey legislature to express its concerns regarding the use of personal email accounts by government officials such as Ms. Kelly, and the relative inaccessibility of important information regarding the Port Authority. First, the ACLU asked the government officials who received its letter to take all necessary steps to prohibit government employees from using personal email accounts to conduct public business whenever possible, while still recognizing, for example, that not all government officials may be provided with governmental email accounts. More specifically, the ACLU asked the Attorney General Hoffman to promulgate regulations and other policies clarifying that, based on OPRA and the retention schedules created by Records Management Services, which is the state agency currently housed in the Treasury Department that is charged with ensuring the proper handling and disposition of government documents, records custodians must have access to and maintain all government records, including those created or received on private email accounts. The ACLU of New Jersey further advised that each action taken by the AG's office and others should specify that when correspondence regarding public business necessarily occurs by way of a personal or private email account, the resulting emails must be printed out or otherwise transferred to the agency as soon as practicable, and then handled the same as any other printed or electronic records. This is especially important when an individual employee leaves his or her government position. Second, the ACLU of New Jersey asked the recipients of its letter to take all necessary steps to ensure that the public has the same access to Port Authority records that it has to the records of all other government agencies in New Jersey. In other words, the ACLU of New Jersey asked Governor Christie, AG Hoffman, and the New Jersey legislature to work together with their counterparts in New York to pass a law mandating that the Port Authority and any other bi-state agencies involving New Jersey and New York be subject to the same transparency laws to which all New Jersey agencies, municipalities, and school boards are already bound. Such a change would require legislation in both states that has essentially the same effect on the Port Authority. The change probably will not come easy, but it should be possible given the current media environment of negative press coverage regarding the Port Authority. Finally, the ACLU of New Jersey requested, pursuant to OPRA and the common law right of access, regulations, policies, or practices upon which the Office of the Governor and the Office of the Attorney General rely themselves when they respond to requests for emails sent to or from a government official's non-governmental email account. Perhaps unsurprisingly, none of the responsive policy documents provided to the ACLU of New Jersey by either agency described any such regulations, policies, or practices. In remains to be seen whether the Office of the Governor or the Office of the Attorney General will do anything to rectify the problems identified by the ACLU of New Jersey. I urge each person here today to help keep the pressure on New Jersey lawmakers by contacting your legislators and expressing your support for the ACLU of New Jersey's recommendations for reform. You can write a letter, you can make a phone call. You don't have to reference our involvement if you don't want, but openness in government affairs is a vital issue to our democratic form of government. And so I hope that everyone here today who is clearly interested in such issues will take it upon themselves to contribute to this effort by contacting the legislators. Thank you very much.
Thank you. We'll have time for questions after we've heard from all of the presenters. Our next speaker is John Reitmeyer, who is a member of the Bergen Records State House Bureau in Trenton. John is a New Jersey native and lifelong resident. He graduated from the College of New Jersey with a major in history and a minor in journalism. He started his newspaper career while still in college as a State House intern for the Atlantic City Press. Upon graduation, he joined the Burlington County Times, where he covered everything from crime to courts to politics for 10 years, winning awards for writing about lucrative public contracts being awarded by county government to steady campaign contributors, and for detailing the forest fire dangers faced by residents living in new developments that were allowed to be built in the New Jersey Pinelands. He joined the Bergen Record in 2007. He's covered the last two governors, John Corzine and Chris Christie, both 2008 political nominating conventions, the 2008 presidential debate at Hofstra University, and the last two gubernatorial campaigns in New Jersey. More recently, he started to specialize in covering New Jersey's campaign finance landscape, the state budget, and other aspects of New Jersey's finances, including the public employee pension system. Currently, he's a member of the records team that's been covering the ongoing controversy over the lane closures at the George Washington Bridge. John?
Thank you. It's fun to hear that all roll out. I do want to thank the School of Public Affairs and Administration for inviting me to speak today and provide a journalist perspective. Really excited about talking shop here. And as Michael said, as a former history major, it was nice to hear the Dean's comments about Ben Franklin and all the role that journalism played really in the founding of our country. What I'd like to do, and I hope that my perspective from covering this issue is helpful to today's conference as a whole. I'd like to talk about two stories that I think happened a few years before the bridge scandal that I think inform where we are and how that story came about. I also think some of my experiences, and I don't want to be all negative here, demonstrate both the shortcomings of New Jersey's public records laws, but also some of the positives and some of the aspects that help us journalists, and myself included, write what I hope are meaningful stories about our governments and our government officials. And I think the public records laws do provide us an effective mechanism to do that, at least one that I've been able to use. So let's start in 2011 real quick. And there were two issues that I wrote about at the time. The first occurred as we were just starting to cover what we would call Governor Christie's shaping of the Port Authority. Myself and a colleague, Sean Boberg, whose name may sound familiar, he's accepting the prestigious Polk Award today for some of his reporting on the bridge scandal. We started looking into we'd heard there were a number of new hires at the Port Authority sent there by Governor Christie who had what you would say questionable resumes for positions at a mass transit or transportation public policy agency. And we were able to compile a list using public records of about 50 individuals who had very strong political resumes, whether it's campaign contributions elections or some other type of elected office or political activity, but not as much, not as many credentials in the public service sector. We were able to write a story, outline each individual, some of their backgrounds. One of them was David Wildstein, whose name, if you've been following the scandal, you'd probably recognize. He's the Port Authority official since resigned whose, I guess we could say his fingerprints have been all over the lane closures. The next story we wrote happened around the same time. There was a massive toll hike and fare increase at the Port Authority in 2011, enacted right around the time of the 10-year anniversary of the September 11th terrorist attacks. And at the time, we were reporting on the effort to have the tolls increased, and both Governor Christie and Governor Cuomo, who have control over the agency, were portrayed as coming in and lessening the increase that was proposed initially by the Port Authority. There were a series of public hearings, I believe all on the same day, all in hard-to-get-to locations that were at inconvenient times for the commuters who used the Port Authority infrastructure to go to work. And those, not surprisingly, those toll hikes were passed easily and are in place now. We were told that if we dug a little bit, there would be communications between the governor's office and the Port Authority that would show us a little bit more of a guiding hand from the governor's office, in this case, Governor Christie in New Jersey. I put in a public records request with the governor's office. I asked for any correspondence, emails, private emails, and I was given just a few very meaningless documents, and was sort of at a roadblock. Now, since this has all occurred more recently, we've been able to report that Governor Christie, in fact, did play a bigger role in that toll hike, and there's some litigation involving the AAA club that seems to be generating some documents. And I asked the governor about that at the last press conference, and he told me he did not want to comment on that story. So I think that puts in perspective a little bit where we're at today, and I'll get to the current events, which is probably what's more exciting, and that is when we first got our hands on these emails, particularly the one from Bridgegate Kelly, Christie's Deputy Chief of Staff, that said, "Time for some traffic problems in Fort Lee." The story itself broke in 2013 during the gubernatorial election, which I was covering. It's a very busy time for journalists, especially in today's environment. We have fewer people to cover more candidates. This past year we had a U.S. Senate race overlapping with governor's race, and we were plenty busy during those few months. And we didn't really recognize, not ashamed to admit, that there was a political element to this right away. Fortunately, we have a reporter who covers the Port Authority on a daily basis who was not involved in the campaign coverage, Sean Boberg, and he was able to stay after this story. The Wall Street Journal did as well and wrote some meaningful pieces. And as time went on, we were able to see that there was a political element, or at least there was many indications that there was a political element to this story that we could look at more closely. We submitted another public records request to the governor's office, asking for any emails, correspondence between the governor's office and Port Authority officials regarding the lane closures. After some delay, we were told that there were no records that were responsive to our request. Again, another roadblock, not one that is surprising. And I remember covering the story with Governor Corzine's emails. Administrations are usually very reluctant to turn over this information. But in this case, had they done so, we would have been able to report probably in a fuller and more meaningful way than we eventually did in a breaking news environment on some of these emails that we were seeking weeks before they were eventually made public as a result of the legislative subpoenas. But on the positive side of this, after those emails broke and the allegations by Hoboken Mayor Dawn Zimmer were raised, specifically that she was being pressured by Christie administration officials to advance a redevelopment project in Hoboken that was being pushed by the law firm that has a lobbying division of then Port Authority Chairman David Sampson. Using public records, we were able to piece together or color in some of the blank pages that were out there. And it was incredibly helpful because it was, in this instance, you had somebody making an allegation. So we were able to use public records to kind of test, you know, look at the periphery and see if we could find evidence that would either poke holes in her allegations or seem to indicate that they had some credence. One of the stories I wrote in the wake of those allegations, I was able to piece together all of the legal contracts that David Sampson's law firm received from the state of New Jersey since Governor Christie took office in 2010. David Sampson was his transition team leader. And I was also able to piece together all of the lobbying receipts that his firm enjoyed during the same time period. And using public records, I was able to show that in some cases, the state agencies that David Sampson's law firm were working for, at the same time, some of the firm's lobbyists were pressing those agencies for favorable outcomes for their clients. And in some cases, I was able to find evidence that they were doing so at the exact same time. Now, this isn't on its face illegal in New Jersey. It happens. We have law firms that also do lobbying, but it's a practice that's been questioned, and it raised. There are those who feel like it gives the firm a leg up for its clients due to that close relationship. And that was a story I was able to write almost entirely using just public records available through New Jersey's law, because not many people wanted to talk to me about that story. And then another one that I think is meaningful, we were also able to find evidence of plans for a rail connection to this redevelopment location in Hoboken. For those who aren't familiar with the city, the path and most of the transportation infrastructure is in the southern end of Hoboken. This proposed property is all the way in the north end, close to Weehawken, and what it lacked was rail access. Through the lobbying efforts of a former Christie administration official who went on to leave the administration, become a lobbyist, and public disclosures of lobbying activity showed that she was someone who lobbied New Jersey Transit, and that the wheels were in motion to run a rail line to that property. Again, all part of the task of taking these allegations that were raised publicly and trying to evaluate evidence that would in some way show whether they were lacking or whether there was some credence. So, in my experience, and I could talk a lot about different stories, I'll leave it at that for now. I think the bridge scandal has demonstrated where New Jersey's public records laws have weaknesses and where there are strengths that journalists can use in a meaningful way to report on stories that I think are relevant to the public interest. And where I think the laws are lacking right now, when we ask for information of an administration and it's in a charged political environment, it could be potentially embarrassing for that administration to release that information. It's often, there are often a lot of roadblocks. It's very difficult. Now, for me, I've been doing this for a while, and I don't have any problem pushing and pushing and pushing and pushing. And right now, we're in court over the emails we sought initially for the bridge scandal. I don't know if I'm the appropriate one to diagnose the remedy, but I think a decoupling in some way of an administration that has a political incentive to hold back information from simply the mechanism that provides that information is probably warranted. But on the plus side, New Jersey law requires a number of different documents, information to be posted online and made available to the public immediately. meeting minutes, campaign contributions, budgets. Right now, you can go online and search lobbying disclosures, public contracts, and this is all put up in the abstract. So it's always there. There may be something that becomes more relevant due to other events, and you don't have to ask for it. It's already there, and it's easy to look at and to analyze and see how it fits in with current events. And in that case, I think our public records law has worked very well, and I know that I've used it to write what I hope are some meaningful stories, both on this bridge scandal and more broadly. And I'm going to leave it at that for now, and if you have any questions later, I'm happy to discuss some of this more. Thank you.
Thank you. Bernard Bell, our next speaker, is Professor of Law and Herbert Hannock Scholar at Rutgers Law School in Newark, where he was Associate Dean for Academic Affairs from 2006 to 2008. He's been a visiting professor at Columbia Law School and George Washington Law School. His numerous scholarly articles have appeared in leading journals, including the Stanford Law Review, Texas Law Review, North Carolina Law Review, Ohio State Law Review, George Washington Law Review, Pittsburgh Law Review, and the Federal Communications Law Journal, and the Journal of Law and Politics. Professor Bell has been active in the ABA section on administrative and regulatory practice, having been a member of the section's governing council and a participant in the section's Interstate Compact project. He's currently chair of the section's Committee on Government Information to Right to Privacy. Professor Bell received a B.A. cum laude from Harvard and a J.D. from Stanford Law School, where he was notes editor of the Stanford Law Review. He clerked for Judge Amalia Kearse of the U.S. Court of Appeals for the Second Circuit and for U.S. Supreme Court Justice Byron White. From 1984 to 1994, he served as Assistant U.S. Attorney and ultimately as Senior Litigation Counsel in the Civil Division of the U.S. Attorney's Office for the Southern District of New York. Professor Bell?
Thank you. Sunlight is said to be the best of disinfectants, so Louis Brandeis wrote in 1913. Closing a major transportation artery to back up traffic in a town as political payback certainly seems an abuse of government authority. Transparency is meant to deter ex ante or reveal ex post. So Bridgegate certainly seems to provide a classic situation in which the transparency requirements embedded in information access laws should apply. I want to make two main points regarding Bridgegate and information access. First, as has been mentioned previously, interstate compact agencies are problematic in terms of information access laws. And to some extent, I'm replowing a little bit of a ground that Thomas Mcleod has talked about earlier. Interstate compacts are agreements between states that must be ratified by Congress. Compact agencies are created by those interstate compacts to perform some function, be it running a multi-state transportation system like the Port Authority, or providing, for instance, hydroelectric power, as many other compact agencies do. The Port Authority, the agency actually responsible for blocking off the lanes of the George Washington Bridge, is not only a compact agency, but it's one of the oldest compact agencies, because the compact itself was created in 1922. Though compacts themselves are federal law, because they have to be ratified by Congress and they're multi-state, compact agencies are not federal agencies subject to the procedural strictures on federal agencies, including the Federal Freedom of Information Act. Nor in most cases are they constrained by the procedural limitations on governments of the member states, including state freedom of information laws. Given that the federal government and all state governments have freedom of information laws which provide individuals with judicially enforceable rights, compact agencies may be one of the few types of administrative bodies that appear to have no judicially enforceable access rights imposed upon them. Congress could, in approving an interstate compact, impose information access requirements on the resulting compact agency, but so far as I know, Congress never has. Signatory states, perhaps not surprisingly, do not seem to provide for information access as a part of negotiating the compact. Individual state laws might, underline might, apply to compact agencies if the signatory states' laws were identical, but this is rarely the case. All may not appear to be lost, however. Since 1977, the Port Authority has promulgated its own Freedom of Information policy. The latest version went into effect April 15th, 2012, so almost 2 years ago. And actually, it's not a bad policy as Freedom of Information policies go. That said, determinations of the Secretary of the Port Authority regarding a requester's entitlement to a document under the Port Authority FOI policy is final. However, tantalizingly, the policy then says, quote, any person who is denied access to a record of the Port Authority may seek such judicial recourse as may be available in either signatory state. It's just one problem. And you can probably guess what it is, right? No court in either signatory state has the authority to enforce the policy. The states of both New York and New Jersey essentially have not consented to suits against the Port Authority by individual citizens seeking injunctions in the courts of either states. They have, however, consented only to the Attorney General of New York or New Jersey seeking such injunctions. So were either Attorney General motivated to seek such an injunction, theoretically they might actually be able to enforce this policy against the Port Authority. But perhaps the provisions of the Port Authority FOI policy could be enforced in federal court. The compact, after all, is federal law, and compact agencies do not enjoy sovereign immunity in federal court, so no consent is needed. However, no federal statute clearly provides individuals a right to seek relief to compel compact agencies to follow their own policies. Remember, compact agencies are not federal agencies for the purposes of the Federal Administrative Procedure Act judicial review provisions. Now, without judicial